I'm here in a special appearance, living flesh and man, God's son. I go by Matthew Aaron Simpson II, Bay. I am competent. I am the age of majority.
Claim notice of
Sir, I've been in
non-compliance. A non-claim notice of non-compliance.
There is no such thing to my knowledge. No such legal.
I know it's not. That informs me that if you're not.
Yes, because I've ordered that his fingerprints, prior to his release, his fingerprints need to be taken. He refuses to advise the court who he is for sure. We need to know exactly who he is, so that it may require that his fingerprints be taken. So until his fingerprints are taken, he cannot be released.
You didn't watch the trial and you didn't testify at the trial?
No.
Okay, so you don't know what happened at the trial?
I was not there for the day-to-day, but I do know what happened. I was here.
What statutory cite do you have for each of those?
I don't have a statutory site. It comes out of law books.
Well, Judge, I don't know that I nor Beaumont has seen a murder like this before, where 4 people were gunned down so close to a college campus, so carelessly, so quickly.
Mr. Stratton is charged with capital murder of multiple persons. Mr. Radford has filed a writ asking for a bail reduction. I think we talked about this and reset it so that the state could bring any witnesses, and then I would make my decision. Mr. Radford, do you have any witnesses?
Yes, we call lively Stratton for the purposes of this hearing only.
Best you can, sir. Please raise your right hand. Do you swear or affirm the testimony in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Go ahead, Mr. Radford.
Can you state your name for the record?
Lively Shay.
And Mr. Stratton, you are the defendant in this case, is that correct?
Yes, sir.
And what is your bond currently set at?
I think after the appeal, I don't think my bond was ever set.
So it's your understanding that you have no bond at this time?
Yes, sir.
What was your bond set at prior to your trial?
I think it was $1 million bond.
Okay. And prior to this incident, have you ever been convicted? Well, you hadn't been, this conviction was overturned by the Court of Criminal Appeals, correct?
Yes, sir.
And prior to this incident, were you ever convicted of any crimes?
No, sir.
Where did you live at the time?
In Beaumont.
In Beaumont, and did you have a job?
Yes, sir.
Okay, how long have you been incarcerated?
Going on 7 years.
7 years? So do you have any substantial savings or any monies that you have collected?
No, as far as my bond, everything would be no contributions from like friends and family.
And if the judge were to set a $250,000 bond, do you think it's possible that you had family members and friends that could make that amount?
It'd be a stretch, but I think it'd be possible.
Pass away.
Any questions?
Mr. Stratton, tell me about the means that your family has. What do your parents do? What kind of assets do they have? What kind of income do they have?
Well, my mom, she gets Social Security disability. My uncle, he's been a professor for the last 30 years. So I'm pretty sure he's got a good amount like saved up in travels and stuff like that.
Do your parents own their homes?
No, man.
Do they have cars? Does your uncle own his home?
He probably does as well.
And he's a professor at Lamar?
No, he lives in another state.
So would you agree with me that amongst the members of your family, you have considerable means to try to post a bond?
I wouldn't even say considerable because I mean, my uncle is really like kind of tight as far as his money wise. So it'd just be even if he feels like doing it for me.
I don't have anything for you, Judge.
All right, thank you. Any other witnesses?
That's all I have, Judge.
Ms. Malfino?
Judge, I will call Detective Coffin.
Good morning, sir. Would you please raise your right hand?
Yes.
Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead.
And before beginning, Judge, I asked the court to take judicial notice of the trial that you presided over some years ago, which gave you obviously a very good insight into the totality of the circumstances and the facts involving this case, and that there were 4 victims of this case. So just ask Detective Coffin, would you state your name for the record?
My name's Frank Coffin.
And were you one of the lead detectives on the case State versus Lively Stratton?
Yes, ma'am, I was.
And that involves the homicide of 4 individuals here next to Lamar campus here in Beaumont, Jefferson County.
Yes, ma'am.
And you were involved heavily in the trial process preparation, et cetera, and you know what came before the court. Is there anything that you would like to add for Judge West's consideration with respect to a bond being set for Lively Stratton?
Well, Judge, I don't know that I nor Beaumont has seen a murder like this before, where 4 people were gunned down so close to a college campus, so carelessly, so quickly. And I can't recall anything like that before. So I think that in itself states that's a significant event as far as murder is concerned.
Detective Kaufman, based on all of your years of training, experience, investigation of homicides, et cetera, do you feel like Lively Stratton presents a significant threat to the community of Beaumont if he is released?
Significant threat.
And do you feel like they're based on the totality of all these circumstances, there's a great likelihood of his flight if he is released?
I would imagine that there would be, if knowing what he's faced with, knowing the amount of time that he'd already been sentenced to prison, the time that he can be sentenced again, there's no upside to not leaving.
I don't have anything further, Judge, unless the court does. From the detective, I just have a couple of statements for argument.
Okay, no, thank you. Thank you, sir.
And Judge,
Oh, you
yeah.
have to ask questions. I'm sorry.
Detective Coppins, you testified at the trial, is that correct?
No, I
You
didn't.
did not. Did you observe the trial?
I didn't.
Okay.
Well, no, I did not.
So you didn't watch the trial and you didn't testify at the trial?
No.
Okay, so you don't know what happened at the trial?
I was not there for the day-to-day, but I do know what happened. I was here at the courthouse helping prepare with evidence, with witnesses,
But you didn't watch the testimony, did you?
with interviews. I did not watch the individual testimony.
Were you aware that the jury found that 2 of the victims evidently that they didn't convict him of killing the 2 guys with the knives? They convicted the 2 guys without weapons. Were you aware of that?
I'm not aware of the details of how many people or of how he killed each person. No.
Okay. That's all I have.
Anything else?
No, Judge.
All right. Thank you, sir.
Thank you, ma'am.
Ms. Malfino?
Judge, I would ask for a bond in this case that is equal with what the facts of this case are, with the fact that we have 4 homicide victims. I think an ask of $250,000 is extremely low. I think it's offensive to the court to ask for a number like that for all 4 individuals, maybe $250,000 per individual. So that's back at the $1 million bond that he was originally set on. The court, unfortunately, is required to set bond on multiple murders in Jefferson County on a quite frequent basis these days. And I think something in excess of $1 million is more than a reasonable ask in this case.
Thank you, Ms. Malfino. Mr. Radford?
Judge, I would point out that the jury did find that there was evidently self-defense in 2 of the victims and that there was an error in the charge and that a new jury may find a different result based upon a new jury charge that should have been propounded to the jury. I think that the court should set a reasonable bond in this case.
All right. So taking into account the testimony of the prior trial that I did preside over and argument by counsel, I'm going to grant the writ and set bail. I am going to find that bail in the amount of $1 million is...
At this moment, the court isn't reacting to emotion. It's calculating risk. The higher the potential sentence, the stronger the incentive to disappear. That's why even the possibility of release becomes dangerous. From the defendant's perspective, staying feels like certain loss. But legally, that exact pressure is what justifies keeping control tight.
Appropriate for the nature of this offense and in line with what I know about the case and the argument. What if there was bond made, there would be a GPS monitoring device required and house arrest. I would obviously, if that bond was made, need to know what that address would be. And then we will get the case set for an announcement and then move it to the trial as quickly as any you guys are ready to do that.
Do we have a discovery?
And Judge, I do have an update while we're here on it.
Sure.
With respect to discovery, Ms. Mayfield was very diligent in going through what we had, what we were able to locate on some thumb drives that we had made as just a backup in this case. Obviously, with the age of the case, et cetera, the court is aware of some of our hurdles we've had in recreating this massive file. Basically, we've also been working with Detective Coffin and BPD to make sure that we can get everything that is available to us to provide to Mr. Radford. I have done a spreadsheet type itemization of the media that I believe is there. What I would ask so that counsel and I are on the same page and to make sure we both have the same things is that he would go through and itemize this in comparison with mine and make sure to let me know if he feels like there's anything that's missing. I will do the same now with this media itemization. I will go through and compare it to the hard copy file itself and cross over and make sure that we're not missing anything, but I do have 2 flash drives to turn over to him today. I also have spoken with multiple family members, and when the court has a little bit of a slower period towards that first part of March, we have meetings set up to meet with the family. I feel like I'm in constant contact.
Okay. All right. So yeah, if you guys will go through that, if there's any issues that you need me to get involved with for any reason, just let me know. Do you anticipate the time to go through some of that to get closer to where we need to be longer? You want to do a little longer?
Yes,
recess?
ma'am. I've got 2 big trials coming up in Orange, one at the end of this month and one at the end of February.
What I'll do is 60 days. Let's just see where we get, start going through that media.
We do the end of March. I'm going to be going in April.
Whatever 60 days is, or make sure you have a vacation letter on file, and we'll work around that and start going through it in the meantime, so that when we get here, you've at least gone through and we know it better where we are on the media and the discovery and things like that.
Yes, ma'am.
Okay.
Thank you, Judge.
All right, you can go back with the bailiff. Thank you, Detective.
Now, do you have an attorney yet?
Yes, I had Charlie O'Hara. I had Charlie O'Hara as a retained attorney. Yeah.
Well, let's go on the record then in BU 2024 CR 420, State of Kansas versus John Raymond Hanna.
Ramon. It's Ramon.
John Ramon Hanna. Please state your appearances.
Thank you, Your Honor. May it please the court, Joseph Baca appearing for the state of Kansas.
Mr. John Ramon Hanna appears in person from the county jail. Mr. Hanna, you asserted that you had retained who? Charles O'Hara?
Yes. I mean, he's retained every month.
What does that mean? You're paying him every month for something?
I just keep him on retainer every month. He's also out of the law offices in Los Angeles as well.
Well, I've known Mr. O'Hara for many years. I did not realize he had an office in Los Angeles. That's news to me, but he certainly is very competent and skilled, so that could be.
In Your Honor.
Mr. Baca.
I'm sorry to interrupt, but I do have some information for the court that I think may help.
Please proceed to.
Your Honor, it's my understanding on this case that at a prior date, a competency evaluation was ordered to be done for the defendant. The state did do some checking into that with the state hospital, and while our notice was sent and the court's notice was sent, it was overlooked by the state hospital, but they are aware of it as of now, so they're going to be getting on top of getting that evaluation done. Now, we're also investigating an issue whether there is a potential federal hold also on Mr. Hanna, but it appears like I don't think we can proceed until we get that evaluation.
Can I say something? I'd like to get can I say something, please? I'd like to put a claim notice of reassurance, a claim notice of non-acceptance, and also reaffirmation of the facts, and a claim notice of discontinuance.
What statutory site do you have for each of those?
I don't have a statutory site. It comes out of law books.
Well, law books all have
What I'm
statutory.
saying,
sides.
what I'm addressing is the claim notice of reassurance and the claim of acceptance is whoever the practitioners of the law, they're actually registered in the Book of Registries in Boston. And I would have my defense attorney put in these claim notices in paper as well. I've already gotten his oral statements.
First of all, sir, I show that when we were here September 29th of 25, you and Darren Patterson, who had been attorney to represent you, had some issue come up in which he asked to withdraw and it was granted. He withdrew. I asked you if you wanted another attorney appointed, and you told me you were going to hire your own attorney. So we set this over to allow you to hire your attorney. Where is that attorney? I don't show any attorney has entered his appearance to represent you today.
Because I haven't. I'll say he's on a retainer fee. He says we have a deal worked out. He's retained.
Well, I'm not sure that he would agree with that, because when he's retained, he shows up and enters an appearance. He sent one of his associates to cover for him in another case today, and that attorney said that they only had that one case and they left. They didn't say anything about representing John Hanna, and they haven't put any notice in file that they're representing you. So it sounds to me like you have not worked out everything you need to with Attorney O'Hara.
I mean, you can say that if you want to, but I would like to address the issue of claim notice of reassurance, claim notice of acceptance, and also claim notice of
Sir, I've been in the
non-compliance. Claim notice of non-compliance.
There is no such thing, to my knowledge. No such legal.
I know it's not. That informs me that if you're not, according to when you take these law tests, if you don't know what a claim notice of non-acceptance is, that you have to be accepted, you only can take this test 3 times in a lifetime to practice law.
Sir,
So I would like to continue with a claim notice of the proclamation of facts, a proclamation of affirmation of facts, a proclamation of discontinuance, a proclamation of non-compliance for not ensuring me that you're ensuring the bond to do what you're doing, and I like to put a proclamation of points of execution.
Sir, there is no such thing in Kansas law. You said you got those out of some Boston law books.
Okay, no, I say Boston law books. I said registry, and the Book of Registry is in Boston. I didn't say Boston law books. I said the Book of Registry. And all I asked for the 922G, if you're insured and bonded to do this, because you have to do it according to federal procedure, according to the United States Constitution. If you can't, then there's no jurisdiction that lacks evidence.
All right, Deputy, are you there?
Yes, Your Honor.
So is he on a waiting list for a competency evaluation?
And the state cannot recommend me to a mental hospital. Thomas Bradley, First Kansas.
Your Honor, I'm not aware that he's on a waiting list or anything, but I can tell you that he is currently being housed for the United States Marshal Service.
All right. So, Mr. Baca,
so talk to the Director of U.S. Marshals.
Mr. Baca, you believe that a competency motion was filed or just discussed?
Your Honor, I believe, I'll check the filing cabinet. What I'm looking at to start is the pretrial that we had in September. The notes indicate that the court ordered a competency evaluation on its own motion. The state was to prepare the journal entry on that date. I believe we prepared that. We've also sent that to the state hospital. As I stated earlier, we did check with the state hospital today. While they received everything, it was on them that they had just overlooked that they needed to do this eval. They have notice of it now, though, and are going to be getting on top of it.
So your suggestion in setting this over would be for what type of hearing?
Your Honor, I do believe if we could set it over for a status just to check for the competency evaluation, take it very likely off the jury trial docket, that would be my recommendation. I think probably nothing less than 60 days, knowing how the state hospitals have their time in the past in getting those done.
I just took competency evaluation at Butner. And when I went to Butner, you raised my bond for me being transported to Butner. They raised my bond when you transported me somewhere. Raised my bond when I was in Butner. Came back and you raised my bond on that. I was found competent, and I did very well on the test. Like I said, this is insulting my intelligence, man. It really is. Because like I said, you haven't addressed the if you saying the 920, I asked for your 922, if you're reinsured and bonded, and I asked your honor as well if you have a 922 reinsured and bonded, and you never addressed the issue. So I'm putting a proclamation notion of discontinuance for this, I don't, but I guess the third time I've said this.
Well, sir, I think I need to do a couple of things. I need to make sure you get that competency evaluation, and I'm going to continue with that order.
You can't do it.
And I want to reappoint an attorney to you because you told me you were going to hire your own and you didn't. You told me today you have, but I don't believe you have. From what I've seen out of the office you said you hired from. But first order of business, when can we do, Jen, a competency evaluation about at least 60 days out?
You take all money from me.
Your Honor, you do have an opening May 11th.
At 9 o'clock?
Yes.
All right, let's do May 11th at 9 a.m. in order that he be brought back or that he reappear May 11th at 9 a.m. on that follow-up of that competency evaluation. And when he gets back, well, I can't appoint our public defender contractor because
You're not addressing the issues. Definitely. She's supposed to address the issues. Thank you. Thank you.
Jen, Jen, do you think that normally I would turn to Mr. Josh? I turned to Josh, but I don't think he's taking those anymore. I think he's got other responsibilities. I don't know if Cooper's would be able to fit one in, but I would like to reappoint. We don't have a list for misdemeanors like we do felons, right?
In the past, Josh cannot take any more appointments.
That's what I thought. Yeah, I used to.
Before.
Say that again, please, that last sentence.
You have appointed William McClendon before, or Chris Pate.
Try William McClendon. I don't want to burn him out on it, but yeah, let's try William McClendon again. Or you said Pate. If Pate would take, you might want to try Pate first, just because of the experience factor and nothing more. I think Mr. McClendon can handle it, but like I said, I don't want to I think anyway, saying less than more, either one of those two would be fine. And we'll set this over, Mr. Baca, to May 11 at 9 a.m. to reevaluate that competency or to review it.
Thank you, Your Honor.
You're welcome. And hopefully, now that you've got the state hospital's attention, busy as they are, they'll make room like they told you they would. So, all right, Deputy, thank you for bringing him out. He's remanded to your custody, to the sheriff's custody.
And Judge, I have Deaton Whiteside at the jail.
All right, when you guys get a chance to bring out Deaton.
Excuse me, I want to fire the attorney. I don't want an attorney.
I can place on the record Oak Park, but he declined my representation.
Okay, thank you. Just kind of hang on and listen in, counsel. I appreciate that.
That's fine. I'll just place on the record, though, if you'll allow.
Sure, absolutely, absolutely. Okay, calling case ticket number Tom King Tom 26 Ocean Paul 00014 in the matter of Matthew Aaron Simpson II. Counsel appearance for the record, please.
Hi, good morning. For the record, Patrick Agdick. I'm here as MIDC counsel. I appear on behalf of the county jail. I did speak in private to Mr. Simpson just now. I indicated that he does have a right to speak with a lawyer. Mr. Simpson indicated that he did not wish to speak with me. Mr. Simpson, you don't care to speak with me, is that correct?
I don't want you on this case.
Understood. So the court's willing to accept his waiver. I'll let him speak directly to the court.
Okay, thank you. Mr. Simpson, would you state your name for the record, please?
I am here in the special appearance. As
yeah, what's your name?
I'm getting to the, Your Honor.
Okay.
I'm here in the special appearance. Living flesh and man. God's son. I go by Matthew Aaron Simpson II Bay. I am competent. I am the age of majority. I am not contract. I do not contract. I'm not that person that you're trying to get me to contract with. So Matthew Aaron Simpson II, I am not him.
Okay, thank you, sir.
And I also would like to say this, I am trust property as well as my car. So I would like this to be, I'm petitioning for this to be seen in equity court because it's trust law.
Thank you, sir.
Thank you, I appreciate you.
No problem.
Hey, Your Honor, can I ask you a question?
Well, give me a second here. Let me go. I got to go through a few things on first, and then we'll get to that. So I have to at least set a bond in this matter. Give me 1 second here.
When you set a bond, the bond is a contract.
Yeah, I haven't gotten anything yet. So hold on 1 second. I appreciate it. Give 1 second, counsel. I will need to grab another file.
Got two universal, take one for evidence. Wait, now you got paper.
Ready to take photos? Let's go again.
Okay, detectives, are you there? And counsel?
Sergeant Kerrigan, Your Honor.
Okay, thank you. Okay, the charges are resisting and obstructing, which is a violation of Michigan Compiled Law 750.881D. Here's a maximum penalty of up to 93 days in jail, possible fines of up to $500. A littering charge under MCL 324.8903 carries a possible fine of up to $10,000. Court's going to enter plea not guilty on your behalf. It's also a driver's license matter before the court, which is under 257.301, carries a maximum penalty of the 90 days jail, fine of $100 on that as well. Court's going to set bond in the amount of $1,000 cash surety, no 10%. Court will also order that, I'm not quite sure, the defendant has not indicated that his name is Matthew Aaron Simpson II. So the court's going to order that fingerprints be ordered prior to the defendant's release on this matter. So do you understand your bond conditions? You also should not drive a vehicle without proper license. Do not leave the state of Michigan without permission of this court. Personally appear for all your court appearances and pick up no new criminal offenses. I have granted court-appointed counsel for you if you should decide you want one later on in the future. Just make sure no driving without license, no insurance, and no plate. You must have those things on your vehicle. Other than that, sir, do you understand your bond conditions?
I don't understand.
Okay. Yeah, it's $1,000 cash surety, no bond, and you were required to take your fingerprints prior to being released, so we know who you are for sure. Other than that, detectives, I'm all set.
All right, Your Honor, real quick, Sergeant Kerrigan, if I can, if he refuses to continue to go along with the program and our booking process of fingerprints, is he being ordered to remand to the county?
Yes, because I've ordered that his fingerprints, prior to his release, his fingerprints need to be taken. He refuses to advise the court who he is for sure. We need to know exactly who he is. So and may require that his fingerprints be taken. So until his fingerprints are taken, he cannot be released.
Okay, then he'll be remanded to the county then, Your Honor, if he does not go along.
That's
I appreciate it. Thank you.
Thank you very much.
Wait, quick question. Your Honor.
Give me 1 second. Give me 1 second here.
Across all 3 hearings, the pattern isn't defiance, it's miscalculation. In the first case, the court is weighing structure against risk. A $1 million bond isn't just about punishment, it's about controlling uncertainty. The more serious the charge, the less the system can rely on trust. Every statement about finances or family support quietly feeds into one question. Can this person be relied on to return? This is the consistent consequence across sovereign citizen behavior. The more someone tries to operate outside the system, the more the system responds by tightening control, not louder, not harsher, just more certain. And that shift from argument to containment is where outcomes start getting decided long before trial ever begins. By the third case, the strategy becomes even clearer. Rejecting identity, rejecting counsel, rejecting contract. All of it is meant to avoid jurisdiction. But in reality, it removes protections. Without counsel, without cooperation, the system fills in the gaps itself through fingerprints, imposed bond, and stricter conditions.